Children who lose one or both of their parents to AIDS suffer due to loss of family income, impoverishment, missed school, work to help support the family financially, and they are exposed to stigma and discrimination. They may also be infected with HIV themselves. The key legal issues of AIDS orphan children relate to inheritance, birth registration, and alternative care. Within the education system, AIDS orphans may confront discrimination in the form of segregation, isolation, or differential and prejudicial treatment. Stigma and uncertainty about HIV and AIDS often lead to discrimination in the education sector. Children may be refused access to school due to their perceived or actual HIV seropositive status, or that of their parents, and they may be required to leave after having been admitted. Sexual abuse can lead directly to HIV infection of both underage girls and boys. Girls are especially susceptible to sexual abuse by older men, frequently called sugar daddies, who seek out younger girls because they believe that they are less likely to be HIV positive. Also related to the issue of legal age for consent to sexual relations is the question of child marriage, which is a sensitive cultural and religious issue. Children orphaned or made vulnerable by HIV and AIDS are at heightened risk for all forms of sexual and economic exploitation. Many countries have enacted legislation that criminalizes child trafficking, commercial sex, and other exploitive activities. HIV infection is a major concern to adolescents and children in general, but the HIV illness does not define the adolescent. What adolescents desire is to live as normal a life as possible, and schooling is one element of normal life. Confidentiality is very critical to mitigate stigma and bias, and discrimination should not occur for fear of loss of opportunities or failure to accommodate the adolescents. There are 3 major federal laws that are likely to affect child's right to education. These are also present in states, and laws pertain to issues of confidentiality, discrimination, and education. The federal laws are Individuals with Disabilities Improvement Education Act, IDEA, the Rehab Act, the Rehabilitation Act of 1973, and the Americans with Disabilities Act, ADA. Ironically, IDEA, that's the Individuals with Disabilities Improvement Education Act, may be the least applicable of laws for adolescents with HIV. Why? Because provisions of IDEA apply only to persons with disability that adversely affects their educational performance. Many otherwise healthy teens with HIV have no diminution of cognitive functions per se. However, if the teenager has comorbidities, for example, psychopathology, reactions to medications that diminish educational performance, IDEA may be applicable. Under the Individuals with Disabilities Improvement Education Act, IDEA, a disabled child entitled to free, appropriate public education at all times. School programs must be individualized to meet particular and specific needs of the child, and the individualized education is crucial. The school, the adolescent, and family are supposed to collaborate in creating an individualized education plan, IEP, that meets educational needs of the student. If the parties cannot agree, the administrative procedures should provide for a due process hearing. IDEA provides for confidentiality of medical information. Private medical information, including HIV information, is on needs-to-know basis and usually limited to nursing and medical staff at the school. In light of the applicability of universal or basic precautions, there is rarely a reason for disclosure to teachers or coaches. the idea also requires school to provide related services at no cost to assist the child with disability to benefit from special education. For example, speech, language, pathology, and audiology services, psychological services, physical and occupational therapy, recreation, including therapeutic recreation, social work services, and counseling services. The Rehabilitation Act of 1973 is a national law that protects qualified individuals with physical or mental impairment from discrimination based on their disability. It applies to employers and organizations that receive financial assistance from any federal department or agency. Examples of impairment, which may substantially limit major life activities, even with the help of medication or devices, include AIDS, alcoholism, blindness or visual impairment, cancer, deafness, diabetes, and drug addiction, heart disease, and mental disease. AIDS is specifically included in the Rehabilitation Act. Unless the HIV infection has resulted in the limiting of one or more major life activities, the child may not qualify. Major life activities include caring for oneself, walking, seeing, hearing, speaking, breathing, working, performing manual tasks, and learning. Many states have regulations to comply with the Rehabilitation Act. Adolescents are usually deemed protected handicapped students if they meet specific conditions. The Rehabilitation Act requires a written service agreement at no cost to the student or parents, which is similar to the IEP, the Individualized Education Plan under IDEA. Also, as with IDEA, protected handicapped students are to be provided confidentiality under the Rehabilitation Act. Like the Rehabilitation Act, the Americans with Disabilities Act is broader than just education issues, and disability need not impede learning per se. Most requirements of the Rehabilitation Act are duplicated in the Americans with Disability Act, the ADA. Primary difference is that the ADA is applicable to schools that do not receive federal money. The school must assure that the programs it offers, including extracurricular activities, are accessible to the students with disabilities. Such accommodations may not be legally mandated if it poses undue hardship upon the school district, but courts are very hesitant to find undue hardship. The ADA specifically provides for confidentiality of private medical information. Disclosure should be only to those who need to know information. For example, school nurse who dispenses the medicines, but not the teacher. There is no justification for broad exclusion from school activities because of child being HIV positive. There is no high school athletic activities which warrant exclusion of a child with HIV as a danger to other children, and non-disclosure of HIV status to coach, team members, etc. may be appropriate. The legal remedies usually start with administrative complaints before the Office of Civil Rights or the Department of Education, and if the complaints are not resolved at that level, litigation may be initiated when possible, with possible award to counsel.